bring in Michael Jaafar. He's Big Case Mike. He's a national trial attorney, and he's ready to chime in here. What do we think should happen? These jurors, it seems like both sides are admitting they've heard from jurors that are claiming they came to unanimous verdicts of not guilty on 2 of the 3 charges. So what to do?
Ted, I hate this, and the reason I hate this is because I hate Karen Reed. And the reason I hate Karen Reed is because I think she's a con artist and a charlatan. But unfortunately, I actually agree with her attorneys for the first time on this specific day. I do want the jury to be polled because here's the thing. Double jeopardy is a constitutional right. It's not something that, when the framers put the Constitution together, the Fifth Amendment, the first 12 amendments, they didn't say, well, one day in the future, if you use a typewriter or a computer or whatever the case may be, and you don't check the right box, the Constitution obviously doesn't apply. They didn't say that, right? It's a constitutional promulgation. Every American has it. So if in fact those jurors were unanimous on the 1st and 3rd charge, unfortunately this charlatan deserves to have her day held. She deserves to have that. She deserves the constitutional right that's afforded to all Americans, right? So I think what's going to happen today is the judge, especially with the looming specter of this conspiracy hoax over this case, right? I think this judge has no choice but to at least cede ground to the defense and let them poll the jury. They're not going to do it today. But I don't see this judge. This judge has called this case right so far. She has not made any mistakes. I've been very proud of her. I've been very proud of the job she has done. So I think she's going to stay in line, stay on brand, and do the right thing again. Remember, she sent the jury back 3 times. When they came back and they said that they're deadlocked, she really wanted a verdict. So I think she's going to latch onto the fact that the defense is saying, hey, there was a verdict on the 1st and 3rd charge. Let's go ahead and dispense of these so we don't have to try them again. I just don't see how this judge will say no to that because it's such a reasonable request. So for that reason, I think that the judge is going to move forward and give the defense what they want. That doesn't mean that Karen Reed is going to be acquitted today. That means that they're going to set up they have a procedure for this, by the way, where they'll bring the jury back without cameras present. They'll poll them and they'll find out what happened. And hey, the jury might come back and say, no, we were deadlocked. There were 2 of us that did not agree, right? We don't know, but we will know. I just don't think this judge is going to throw this out and say, nah, you know what? The form was filled out in a certain way. We're done. She has every right to be upset, by the way, with the jury foreperson, but I don't think she's going to say no just out of hand and say we're not going to even go down this thread.
Michael, you think she does have a right to be upset with a jury foreperson? I mean, these verdict forms aren't exactly that self-explanatory. I mean, we even saw in this case, Alan Jackson had asked about some additions on the verdict form. So you think she has a right? She could have afterwards maybe said, just want to make sure that this is, no one can reach a verdict on any of these charges, that unanimously you cannot reach a verdict on any of these charges. I mean, I know under the law that can be dicey to do that. She just declared the mistrial, but I don't know, do you think she has a right to be upset?
I think if it comes back after they poll the jury that they were unanimous, I think she has every reason to be upset if that happens. Now, my personal opinion is I don't see how they could make that mistake because they were sent back 3 times. I just don't see how that mistake could have been made. And to be quite frank with you, if I have to dig into the annals of my brain, I assume that some of the non-high public profile cases once in a while have. I think there was a case one time that I saw when I was waiting for a motion where another attorney brought up a motion. There were no cameras in the courtroom. This is in a Detroit courtroom. I could see it happening, but a high-profile case, I just don't see how it can happen. But I'm curious. I want to know, and I want to put, because Karen Reed and her attorneys have played the victim card too many times for my taste, and I actually don't. I think that they have been basically hoodwinked by their client, and I think that this is just on brand, right? I don't think her attorneys are fabricating this at all. They would never do that. But I think the judge would have every reason to be upset with the foreperson if they did a polling and it turns out that they were unanimous, but the form were filled out and conveyed improperly. Again, I don't see how that could be possible, right? But it could be.
So, do you think she hit him on purpose, like the Commonwealth? Like, no. I got mad, I'm gonna kill you, John. Or what do you think happened?
My theory is pretty clear. She hit him. I don't think she did it intentionally. And I've maintained throughout the trial, I don't think that murder too was proven. I don't believe that Karen Reed had any motive to kill John O'Keefe. But all the evidence was overwhelming against her, hitting him intentionally or not, and then going home. She was so drunk, Ted, that the day after, she was still drunk. She was still intoxicated. The public don't know how much you have to drink to hit a .08. She was at a .08 the day after, right? She was so intoxicated. There was a snowstorm, and her attorneys brought so much looming specter of conspiracy and cover-up, and when they took the trial, when it was their case, they had the case for only 2 days. It did not bring up a single witness that pointed to the Alberts or brought up any type of conspiracy, right? Their whole case was, it's not possible for a car going 25 miles an hour to kill a man. But even their witness, the person that was an expert for the federal government, came in and said, hey, you know what? Actually, on cross-examination, you know what? Yeah, if you hit the curb going back, that would cause enough force, 1,000 pounds of force, to kill you. And I said a client died on April 20th by slipping back and hitting his head on the staircase. A young, healthy man died on the spot. So it happens. And even their witness said, yes, that could happen. All the evidence, it narrows right to Karen Read. Whether or not she did it intentionally, that I don't believe that has been proven.
What do you think, Michael, the state, the Commonwealth there in Massachusetts, obviously the mistrial was declared then. I was surprised. I think I was anchoring and filling in, and you said they absolutely are going to bring these charges again. I think you did say that. So yeah, you're not surprised that they did. Yeah, I remember that.
No, they have to. They have to because there's too much.
Even the murder too? I mean, you got Proctor's not going to get any better the second time around. In fact, he's gotten worse. He lost his job. Other investigators are now under investigation.
Yeah,
their case failed miserably on the murder too. You said it yourself, Mr. I Hate Karen Read. You don't even think they got the murder too. On what planet should the Commonwealth come back and say, we'd like to do a redo on the two? Now, even when you throw the juries, this whole juror fiasco into the mix.
I said during the trial that 5 days after this trial is done, they're going to fire Michael Proctor. Then 6 months after the trial is done, they'll deny his retirement pension. Then 6 months after that, he will hire a private firm in Massachusetts, sue the Commonwealth, and then a year after that, they'll privately settle it out of court with a non-disparagement agreement, right, on both sides. So they've done exactly what I predicted they would do. They fired Michael Proctor. He was absolutely a villain. He was the villain of the case. And to be quite frank with you, Karen Read was throwing out the conspiracy hoax before they even knew what the text messages with Brian Proctor yielded, right? That's one of the other things that made the whole thing a hoax. But do I believe they should bring the murder to? I've said that this case is like an airplane that reaches VO2 speed upon takeoff, which is the speed where an airplane can no longer safely abandon takeoff. It has to take off or everyone dies. This case is too much, and Karen Read brought it that way. She brought up the conspiracy hoax. She conned her attorneys. She came into their office. She sold them on the hoax. And then the Commonwealth, to their everlasting shame, did not give up the evidence for them to independently test the DNA, which they should have, which then allowed her attorneys, gave them the air to say, you know what, there's a cover up here. They won't even let us test the DNA for canine DNA. They must be covering something up. Look at these. Look at this picture of the arm of John O'Keefe. These are dog bites from within the Albert House, right? So the Commonwealth is not blameless here. They've made tons of mistakes. Who gave that, and they gave air to this whole entire conspiracy hoax. But no, I don't believe that the murder too was proven. I don't believe it could ever be proven. Should they bring it back? I think only because of the looming specter, public specter of hoax. They have to bring it back. And Matt Johnson even said outside of that courthouse, the balance of people who are in favor of Karen Read versus against her is shifting against her. I think it has everything to do with the fact that everybody has seen that the whole conspiracy hoax that they promised the public, we're going to show you the Alberts and the police and Higgins and all, it was all a hoax. So that's. You're going to have to tell me to shut up, Ted, because I get too lazy to stop once I get going. You're going to have to tell me to shut my mouth.
Yeah, you love talking about this one, Michael. Wow. They were all this.
He's not everybody. This is one of those rare cases that everyone has the same look at the evidence. It's all out there, and people have very different opinions about it. And there's so much compelling nuances to it, that it is just a rare case, and it's not over.
Not over.
Well, let's bring back in Michael Jaafar for his opinion on this one. Tell us, has he wanted to represent himself, had trouble getting along with others, now he seems to have settled in. What's your gut tell you on this case? What should we be looking for as we watch starting next week?
This is very important. It's funny that we were talking about the Karen Reed case on the prior block, and here's why I bring that up here. He alleged a hoax and a cover-up that he was being framed by police. Attorneys, whenever their client tells them, every defense attorney can attest to this. Probably 90% of your clients, when they first talk to you in the first conversation, they either feel that the police were covering up the crime or that they were treated unfairly, at a very minimum. I don't recall, maybe 1 out of 100 people will tell you, hey, I was treated fairly, I did this, I need to take a plea. Most people will tell you there's a cover-up, there's a conspiracy. If you look at this person right here, and he went through 3 attorneys before he settled on the 4th, I have to assume, none of us were in the room, I have to assume that those attorneys, they butted heads because he told them, you need to go after the police, you need to go after this, and the attorneys told him, look, we got to be rational. I've got an obligation to protect you, and I'm not going to protect you by going in there saying that the police and the government and the whole world is against you. We've got this evidence we've got to contend with. We've got the hat. We've got the DNA evidence of Gehrman under. Look, we've got your fingernails under your DNA under his fingernails. We've got to contend with all that. We're not going to be able to say that the police took your DNA and put it under his fingernails to cover you up. I don't think that's what you want me to do. Well, that is what I want you to do. And so they would have fired one. They would have parted ways. And so what I'm looking for, to answer your question, Ted, what I'm looking for is the first thing that I'm looking for, the opening statement by his defense attorney, because that will tell us whether or not how they were able to see eye to eye. I think that his attorney would have told him, look, if I'm going to represent you, you're on attorney number 4. You're going to spend the rest of your life in prison if you don't have an attorney. Let me go in there and fight this, but I'm not going to fight it by saying that you have been covered up, you have been framed. I'm just not going to do it. So that's what I'm looking for, Ted, because for me, I'm obsessed with this profession. I love to see the art form of defense attorneys coming up with arguments and defending their clients because they have very difficult jobs. And for me, I think this defense attorney with his stature would have convinced his client to be rational and to fight the evidence as it is and to create reasonable doubt and not say that he was framed. That's what I'm looking for. And I think that's what would have happened. I don't think an attorney worth his salt, every attorney knows they can only bring up the frame cover-up thing once in their career, and they better be right or their career is over. It's not a thing that happens all the time. It happens in movies, but it doesn't happen in real life. It's very, very rare for you to see that happen, and it's very rare for that to even happen, right? Let alone be proven. So that's what I'm looking for.
Let's play a little bit of a clip from an interview. This is about a minute long. It was a jailhouse interview he did, and I believe he's talking about domestic violence incidents. Let's listen to that.
I would drink one drink, but one would turn into a dozen before I knew it. I just would drink until I blacked out. And for a long time. And then, of course, I didn't drink every day. It's on those days where I would drink, I couldn't control myself. If I had one, I had to have a dozen, and I'd black out, not knowing what I did the next day. And you know, I tried to tame it. You know, I wanted to be like everybody else. I wanted to be like people who could have 1 or 2 drinks and not black out. And so I did that for quite a bit of my adult life. You know, so whenever I'd go out to functions or whatever, I would, unfortunately, by the time I got home, I'd be blacked out. And regretfully, when I had a couple of years ago, when I blacked out, it scared my wife and it scared my kids. I didn't hurt them, but I scared them enough to call the police on me. And after that day, I stopped drinking. I said, I'm not perfect, and I just wanted to try to, I just want to try to do my best and be the best person I can be. And so I just wanted to explain what occurred with that domestic violence charge.
All right, Michael, that was a jailhouse interview that he did with a reporter there in Las Vegas. That doesn't make him sound very good. What do you think about that?
No, I mean he's not a perfect person, and he's got a checkered past, and I don't believe that this person, the way he's constructed and situated, would make him the type of person it's impossible for him to have committed this crime. He could have committed this crime. It would be bizarre for a public official to murder a jury. I mean, that would be completely bizarre, and that's why I'm really looking forward to the evidence that's going to be presented. I'm really looking forward to the openings by both sides. But the domestic violence, I've represented a lot of people who've fought domestic violence cases, and they kind of all go down the same path, right? They kind of all have the same lineage, origin story, if you'd say, right? And the origin story is not good, because for you to raise your hand, and there's no evidence really that he hit his wife, but he scared her and she called the police, and he said that he's sober, and there's ways of testing that. And I mean, at the end of the day, is he a monster yet? Have they painted him to be a villain? We have to see what the prosecution is going to do. Obviously, they want to paint this guy to be a villain. I don't know how they bring in the fact that he has a prior domestic violence charge. I don't think they'll bring it in. But in the day and age right now, the jury pools all know everything about every case. That's my conspiracy theory. When they sit down for a case, they've researched everything. I think every juror going into that box is going to know that he had a domestic violence charge, even though they're not supposed to know it and they're not supposed to bring it up or look at it. I just don't see how it's brought up. Go ahead.
I think the jury's going to find out about it, because I think he's taking the stand. He's a politician.
Yeah, I was going to say.
He's the things that he has done. This interview he just did. He's that guy that is going to be more than willing to tell his tale. And as soon as he does, then he does have to spin that yarn about the DV call, and maybe the jury's going to accept that. Let's say you're representing a guy like this who is itching to get up there and tell his story. How do you say, whoa, I don't think this is going to be a good idea? Because it is up to him.
This is a case where I don't believe that this person should take the stand. There's been many cases where I believe that the defendant should take the stand. Anytime that there's a self-defense defendant, right, they have, in my opinion, they have to take the stand unless they have a checkered past, right? Like Marcia Thompson, I believe before that trial even started, she's going to take the stand. Ashley Benningfield, she's got to take the stand. People like that have to take the stand. This is the opposite. I don't believe he should take the stand. And I think this is one of the things about having an attorney of the stature that he has. The attorney can exert some control and tell him, you have to abide by my rules, and my rules are 1, 2, 3, 4, 5. No conspiracy hoax, no framing. You can't take the stand, because if you take the stand, it's fraught with peril. You do have a police run-in. You do have a checkered past. You cannot take the stand, and you're going to lie, and you're not going to come. I mean, I'm looking at this guy in this police interview. He doesn't look credible, to be quite frank with you, Ted. This is not a good witness, right? Marcia Thompson was a great witness. He's a terrible witness, right? In terms of the checkered past, I think the juries can look past it. Listen, I have a saying. I've seen people get convicted with less and acquitted with more, right? So we have to really see the evidence, because the hat being cut up and being found in his home, and the DNA evidence of him being on Gurman, that is damning evidence, right? We have to see cell phone evidence. I don't think he's dumb enough to have carried his cell phone when he went to do the stabbing, if he went to these great lengths to cover it up. But I don't know if he has an alibi. We have to really see the openings on both sides, and the openings will give us the themes of whether or not he has any shot at an acquittal here. So those are my thoughts. But yeah, I don't think this person should take the stand. To your point, Ted, he might force himself to take the stand at the last moment. I've been on the receiving end of this. When I was a public defender, I had no leverage with my clients. Somebody wanted to take the stand, I had no choice. They had to take the stand. But I don't think it's going to happen here.
It's going to be another good case to watch.
Starting next week, jury selection is set for Monday afternoon, so we'll be all over that.
Michael, thank you very much. Still with us, national trial attorney Michael Jaafar. Now we're going to talk about this case, Michael, that's also going to be starting next week. A lot of just horrific details in this one that we'll be expecting to hear a lot about.
Yeah, this case is what I call just not a case, right? Like this guy's going to get sentenced to death, right? Even if he didn't have his co-conspirator testifying against him after having taken a plea where she's going to be spending the rest of her life in prison, even if he didn't have that, just the evidence that already exists in this case, where they found the remains in the freezer cut up in his home, the depravity of it, the blunt force trauma, the constant raping, all of that's death penalty material but he's going to also have his co-conspirator testifying against him. So this is one of the cases where you're a defense attorney. These are the cases that, you have to, you get a level of experience in coming up with arguments in cases like this that you can't get anywhere else, because as a defense attorney, all you're trying to do is try to find a way to combat the death sentence. That's all you're trying to do. No defense attorney ever wants to be known as the person, the girl or the guy who had a client get sentenced to death. You don't want to be that. That's one of the things in our industry, like, oh, he had a client get put to death. So few people get put to death, right? You don't want to be painted as one of the attorneys who had a client go to the electric chair, right? And so I'm sure his attorneys have reached out to the state and said, look, he'll take a plea, life in prison without the possibility of parole. In his allocution, he'll say what he did. And the state of Tennessee would have said, no, we already have one person, one of the co-conspirators. We gave that deal. That deal's off the table for your person. It was never on the table for your person, but it's definitely not on the table now. So for me, I'm looking for the defense attorney to come in and say he had a horrible life, he had a terrible life, he did this, he did that, he was trying to do good, but the demons came in, they got him, he killed her. Once he killed her, he got scared. That's what I'm looking for. I'm not looking for them to try to get him off or get some sort of a reduced manslaughter. I'm not looking for any of that. I'm looking for his defense attorneys to lay a foundation and a record so that after he gets convicted, they can convince a jury to not recommend death to the judge. That's what I'm looking for. It's going to be very interesting.
Yeah, and a tough battle.
And it's out of a horror movie. What is alleged here in this case is the worst, everyone's a father's worst nightmare, a woman's worst nightmare, being kept and raped repeatedly in somebody's home. Two people, the man and the woman.
And then you even heard that man during that story that we just played about how he was afraid of him with his eyes. And
yeah, he's not someone that should be running around ever. And a win here, though, is, Michael, to your point, just avoiding the death penalty. At the end of the day, most cases are tough to get a death sentence on because people you could be death penalty all you want. Once you're in that jury box, though, and you have another person's life in your hand, it's very hard. I always come back to Nicholas Cruz. That jury felt bad on some weird level for Nicholas Cruz. I don't think this guy is going to have that going for him.
Yeah, no, I mean, after he gets convicted, they're going to be looking at mitigating factors and aggravating factors. He qualifies under Tennessee. I think they have 6 aggravating factors, right? He qualifies under all 6 aggravating factors. He even he can't even come in and say, well, I don't have any prior run-ins with the law. He does. He's allegedly occurred a rape of a 3-year-old. He's got baggage, right? He's got no mitigating. This is a death penalty case. This is a death penalty case par excellence. Like, it just straight out of Central Casting. He's going to get put to, if you don't put this guy to death, who do you put to death in Tennessee?
Right, good point.
All right, Michael, thank you so much.
Still with us, national trial attorney Michael Jaafar. And Michael, before we talk more about it, I want to play something that just happened a few minutes ago while we were in the commercial break. We've seen these two competing sides. It used to just be the free Karen Readers, free Karen Read, free Karen Read. Every single day, every motion hearing, all during trial, they were forced to move away from the courthouse. Well, the other side has a legit contingent now saying justice for John O'Keefe. They've transitioned to lock her up, lock her up. Take a listen.
Yep.
Mike, have you ever seen anything like this outside of a courthouse? I mean, this is like, I guess it's indicative of our country where we are politically. People are just mad. What's your take?
Yeah, Ted. For the lead up for this trial, I told everybody. I said, listen, the specter of conspiracy in Boston and the surrounding areas, Massachusetts, is different. It's different. If you ask anybody, hey, do you think that there's corruption in your local city, your police? They'll say, yeah, there's some corruption. Of course, there's always corruption. It's different in Boston. It's different in Massachusetts. It's just unique. It's a whole different. It's a different thing. It's just takes a life of its own from the Whitey Bulger days and the mob and the Irishman. Like, those people distrust their organization and that's why I said Karen Reed was a con artist. She knew all she had to do was throw a flame into the powder keg and light it on fire to deflect attention from herself, because she knew she had free Karen Reed. Give me a break. She's already free. You guys are, anyone who's saying free Karen Reed, look, what are you talking about? She's already free. She's going to make a book deal. She's a liar. She's a charlatan. She's a con artist. And one more thing, Ted, she had every motive to cover this up. I don't believe she had a motive to intentionally kill John O'Keefe, but she had every motive to act after she accidentally hit him to cover it up. And here's the motive. She knew she was drunk. She knew if she called the police, and even if she thought, well, maybe he just broke his leg, I'm going to take off. If they find out later on, they won't know the real thing I'm hiding, which is that I'm drunk. Because if she would have just hit John O'Keefe, and then they tested her blood, and she was at a 0.3 or a 0.25. If she was that drunk, she would have been facing felony aggravated, bodily injury charges in Massachusetts. She would have been facing minimum 5 years, even if he just broke his leg, if she called the ambulance and they tested her alcohol. So she had every motive to go home. And then we know she started pacing around the house, concocting a story, doing Google searches. And then, well, maybe he got hit by a snowblower. Maybe he got hit. Maybe she started coming up with her theory. And so she had every motive to cover this up. And so that's why initially you saw so many people in the courthouse steps saying this was a cover up. We looked at the pictures of John O'Keefe's arm. We're all detectives now. We all know what we're doing. We know there's corruption. It was the Alpers that did it. It was the dog that did it. There's a cover-up. They're covering up for their own. But now you're seeing it shift back towards John O'Keefe, because actual rational people are taking a step back and saying, wait a minute, hold on. You told us for a year and a half that you have all this evidence that's going to blow the lid off this conspiracy, and people are going to go to jail. There's nothing. There's nothing there. You just made the whole
there's
thing up.
eyebrow raising throughout. This is not a cut and dry. This is not like, oh, she did it for sure. I mean, let's face it. John O'Keefe's injuries make you think. Trooper Proctor makes you think. There are things here that there's a there. The defense didn't just willy-nilly say conspiracy.
No, the defense, here's the thing, Ted. They were sold on this theory by their client. They had no choice but to do it, and I'll tell you why. If you go back to the motion hearing last year, a year before the trial started, they came in and they said they were legitimate. They said, we want to test the DNA evidence ourselves, and we think that they're covering things up. Why won't they let us test the DNA evidence? Because you have to let the defense test the DNA evidence independently. You can't just expect them to believe yours. So they had to say what they said, but after they got everything they wanted, and it all turned out to be bogus. That's why they presented no evidence when they had the 2-day trial of a conspiracy.
Mike,
Sorry.
thank you. There's Karen Reed. We're taking a look live inside that courtroom.